Our second session involves a discussion of the Affordable Care Act, Social Security and medical set-asides, with an emphasis on how each dovetails into the law of California workers' compensation. Joining this panel will be Ben Helfman, Stephen Chapman and Michael Sullivan. Ben Helfman is a partner with the firm of Leap, Tesher, Helfman and Zanzi. Mr. Helfman is a graduate of the University of California at Los Angeles, BA 1985, and the University of Pacific McGeorge School of Law, JD. He is also a member of the State Bar of California and California Board of Legal Specialization in Workers' Compensation. Mr. Helfman is also the president of the Shasta County chapter of CAAA. Mr. Helfman will be joined by Stephen Chapman. Mr. Chapman received his undergraduate degree in business and psychology from the University of Redlands in 1979. He completed his master's coursework in rehabilitation counseling at California State University, Los Angeles. He is a lifetime member of the National Structured Settlement Trade Association, where he serves on the Government Benefits Committee. Mr. Chapman works with hundreds of attorneys throughout the state of California and has worked in the resolution of cares in more than 20 states. He provides education and training seminars for attorneys, claims professionals, judges, life insurance company executives, and other structured settlement professionals. Mr. Chapman is entering into his 28th year as a nationally recognized leader in his field. Rounding out this panel is Michael Sullivan. Mr. Sullivan is the general managing partner of Michael Sullivan & Associates LLP, an aggressive workers' compensation defense firm with 5 offices throughout Southern California. In 2011, Mr. Sullivan published Sullivan on Comp, a 12-volume comprehensive objective treatise on California workers' compensation law, which since 2011 has become one of the top workers' compensation legal treatises in the state. Let's listen to the next panel, which is already in session.
You know, I've already gone through this panel. Of course, it's made up by Michael Sullivan of Sullivan on Comp, by Ben Helfman of Leap, Tesher, Zanzi and Helfman?
Helfman and Zanzi.
Helfman and Zanzi. Of course, Ben is concerned about that. And then also Mr. Steve Chapman.
And they're going to give me a microphone.
No. What we decided, what we decided on the microphones is you guys would share. Is that okay?
I'm just kidding.
Okay. Now we want to hear the defense, especially. This is not a defense conference, okay? But anyway, the topics that they're going to be discussing are going to be CMS MSAs, Social Security, and then the Affordable Care Act. So I'll just turn it over to them. I don't know who's going to moderate or who's handling it.
Sit down here or you want to go there? I'm going to sit down here and talk.
Me too.
Yeah. You want to sit down here or you going to be up
No, I'm going to be up here.
Okay.
Guess he's going to be up there.
He's going to be up there?
Thanks, Rich, for that introduction. So, who am I? I'm a certified specialist by the State Bar of California, and I'm president of the Shasta chapter of California Applicants Attorneys Association. It seems like in perpetuity until someone else is willing to do it. Who I'm not a Social Security expert. Question, what does an applicant's attorney need to know about Social Security? I don't need to be an expert at Social Security, but I do need to see the issues. What does Social Security say? To qualify for Social Security disability benefits, you must have first worked in jobs covered by Social Security, and then you must have a medical condition that meets Social Security's definition of disability. In general, they pay monthly cash benefits to people who are unable to work for a year or more because of disability. How much work is needed? The number of work credits needed for disability benefits depends on the injured worker's age when he became disabled. Generally, the injured worker needs 40 credits, 20 of which were earned in the last 10 years, ending with the year he or she became disabled. However, younger workers may qualify with fewer credits. Now, I'm getting into some very technical details here. As an applicant's attorney, I don't necessarily really need to know this. I do need to know the issue that they need enough credits. And that affects whether they're going to qualify for Social Security disability, which generally pays more money, or whether they're only going to qualify for Social Security supplemental income, which is needs-based. It's essentially welfare, federal welfare for disabled people. The rules are as follows. Before age 24, you may qualify if you have 6 credits earned in the 3-year period ending when your disability starts. Between ages 24 to 31, you may qualify if you have credit for working half the time between age 21 and the time you became disabled. For example, if you became disabled at age 27, you would need credit for 3 years of work, 12 credits out of the past 6 years between ages 21 and 27. And if you're age 31 or older, in general, you're going to need to have the number of credits that is shown on the slide I'm about to show you. What's the takeaway here? Have your injured worker, if you're an applicant's attorney, call the Social Security Administration and find out if they have enough credits. Social Security will tell them. Once they know if they have enough credits, they can know whether they're going to be disabled. Another important thing that I haven't brought out here is how long do they have that they remain insured for Social Security disability after they stop working? It's important that their application for disability and their onset date be within that insured period. Otherwise, they're only going to qualify for SSI. So this is the chart I was telling you about in the last slide. I'm not going to go over the slide in detail, but as you can see, as you get older, between age 31 to 62, the number of credits goes up. What Social Security means by disability. The definition of disability under Social Security is different than other programs. Social Security pays only for total disability. No benefits are payable for partial disability or for short-term disability. Disability under Social Security is based on your inability to work. They consider you disabled under Social Security rules if you can't do work you did before, and they decide that you cannot adjust to other work because of your medical conditions, and your disability is either lasted or expected to last 12 months or result in death. That's what they mean by short-term disability not being covered. This is a strict definition of disability, and Social Security is assuming that for those people who have disability that is not going to either last more than a year or expected to last more than a year or result in death, that they're going to rely on other sources of either income or benefits from other sources, including potentially state-based programs. How does Social Security decide if you're disabled? If you have enough work to qualify for disability benefits, like I discussed a moment ago, Social Security uses a step-by-step process involving 5 questions. Are you working? Is your condition severe? Is your condition found in the list of disabling conditions? Can you do the work you did previously, and can you do any other type of work? Now, again, the takeaway from that last slide is not necessarily how I'm going to I'm not going to approach the issue in terms of how would I prove up disability at a Social Security trial, but I do need to have an understanding of what the issues are so I can at least refer that injured worker out to a Social Security disability attorney. On the question of are you working, taking 2014, if you're working in 2014 and your earnings average more than $1,070 a month, you generally cannot be considered disabled. If you're not working, then Social Security will send that person's disability application to the Disability Determination Office that will make a determination about their medical condition. That brings us to the concepts of substantial gainful employment. In order to qualify, a person generally has to be making less than the monthly SGA for their type of disability and be expected to last more than 12 months. I don't know how well you can see that chart up there, but you'll notice I've drawn a box around the 2015 figures. For a blind person, it's 1,820, and for a non-blind person, it's 1,090. By the way, I got almost all of these images and slides off Social Security's own website. Incredibly well constructed for someone who doesn't know anything about Social Security even. So that's about as much as I really need to know about how to qualify for Social Security if I don't consider myself an expert in Social Security. What I'm going to need to know about anytime I'm settling a workers' compensation case is the concept of offset. So Social Security can be reduced or totally offset by either federal or state workers' compensation payments, which we're really concerned about in this conference, as well as federal, state, or local public disability benefit payments. The concept of public disability payments is beyond the scope of this presentation, but there are many different kinds of disability payments that actually don't qualify for offset, certain federal program benefits, and I invite you to do a Google search on Social Security PDP payments, and you'll find a section of the Social Security's website that has a list of some of the types of disability payments that are not offset. Offset does not apply if the disabled worker is a disabled widower or disabled adult child. That sometimes comes up in my practice. I ask someone if they're receiving Social Security disability benefits, but I find out that they're not actually receiving on account of their own disability, but on account of one of these two issues. So the offset is based on the higher of 80% of the worker's average current earnings, or the total of such individual's disability insurance benefit for such month and all other benefits payable for such month based on such individual's earnings record prior to reduction under this section. Average current earnings is the largest of average monthly wage used for purpose of computing the individual's disability insurance benefit under the Act, or 1/60th of the total of the individual's wages and earnings from self-employment for the 5 consecutive calendar years after 1950 for which the wages and earnings from self-employment were highest, or 1/12th of the total of the individual's wages and earnings from self-employment for the calendar year in which the individual had the highest wages and earnings from self-employment during the period consisting of the calendar year in which the individual became disabled and the 5 years immediately before that. This is often the one that results in the highest calculation of earnings on the basis that people's earnings tend to go up over the years. Again, the takeaway here is that I don't have to be an expert on how I calculate average current earnings. I want to be aware of there being more than one method to calculate average current earnings, and I'm going to tell my client to go to the Social Security office and come back with the figure that I need so I can calculate my 80%, so I can calculate whether offset is going to occur. What you can see from this is that very high wage earners are going to have less of a problem with offset than very low wage earners. The example I often use in my practice when I'm explaining this in a somewhat simplified manner for my clients is if my monthly earnings that Social Security used to calculate my benefit were only $1,000 a month, and the 80% is going to be $800, and I'm already getting, let's say, $600 a month from Social Security, I'm only going to be able to get another $200 a month from a source that is subject to offset, like workers' compensation payments, before offset kicks in. So in my example, if I'm using that $1,000 a month figure and I'm subject to offset for anything over $800 and I'm getting $200 a month, no offset, I still get my $600 a month from Social Security. But if I begin receiving $300 a month from workers' comp, I'll only get $500 a month from Social Security because 5 plus 3 equals 8, and I remain under that 80% figure. So, first example from the Social Security's website. Effective September 1981, Harold is entitled to a monthly disability primary insurance amount of $507.90 and a monthly public disability benefit of $410 from the state. 80% of Harold's average current earnings is $800. Because this amount, $800, is higher than Harold's disability insurance benefit of $507.90, we subtract Harold's monthly public disability benefit of $410 from 80% of his average current earnings of $800. This leaves Harold a reduced monthly benefit of $390. Example 2 from the Social Security's website. This one takes into account the fact that in certain instances, members of my family may be entitled to disability payments because of their relationship to me. So in September 1981, Tom is entitled to a monthly disability primary insurance benefit of $559.30. His wife and 2 children are also entitled to monthly benefits of $93.20 each. The total family benefit is $838.90. Tom is also receiving a monthly workers' compensation benefit of $500 from the state. 80% of Tom's average current earnings is $820.10. Because the total family benefit of $838.90 is higher than the 80% of the average current earnings of $820.10, we subtract the monthly workers' compensation benefit of $500 from the total family benefit of $838.90, leaving $338.90 payable. This means that the wife and kids get nothing. So that gets us to how I can maximize my client's Social Security benefit by taking certain steps in the process of settling the case. And this is often referred to as a Hartman formula. What's going on in a Hartman formula is that I am saying to the Social Security Administration, by including language in the compromise and release, generally works best in a compromise and release, but according to the research I'm doing here, may even apply in certain situations where there's a lump sum settlement for other than a compromise and release, perhaps in a compromise and release with future medical open. If the lump sum award is $100,000, actually, before I get into the figures, let me finish explaining what we're trying to do here. By telling the Social Security Administration in the settlement documents themselves, and by having the workers' compensation judge at least note and approve the life expectancy calculation, I say to the Social Security Administration, I'm going to use artificially low numbers here to demonstrate what I mean. If a person has a 1,000-week life expectancy, and we have a $1,000 settlement, we can divide that $1,000 settlement over 1,000 weeks, then the amount that is subject to offset becomes only $1. And if that dollar is less than the space that I have before I hit the 80% mark, I'm going to receive no offset at all. And if I can reduce that amount to less than it would otherwise be, if I stipulate and receive under current 2014 rates $290 a week, or under earlier rates $230 a week, and I can bring that offset amount below that figure, then I'm at least going to minimize the effect on the Social Security award. Again, this example from the Social Security's website, there's a lump sum award of $100,000, an attorney's fee of $15,000, excludable medical expenses of $10,000, and a life expectancy of 2,000 weeks. The gross proration, before deciding which method of proration most benefits the worker, $100,000 is divided by 2,000, we get 50. Medical expenses and attorney expenses are then deducted using the most favorable proration method. Methods of prorating excludable expenses. Now again, the takeaway here is not, as an applicant's attorney, that I have a complete understanding of how to calculate this, but to be aware of there being several proration methods that may further the goals my client and I have worked out in the settlement. Some of them move the offset further into the future, some of them move the offset further into the present. So there are different ways of calculating it. Method A excludes the expenses from the beginning of the proration period, thereby delaying the imposition of the offset. Method B spreads the expenses out over the life of the award, and Method C excludes the expenses from the end of the proration period, thereby shortening the offset period. This removes the offset at the earliest possible time. Using Method A, you divide the excludable expenses by the weekly rate, resulting in the number of weeks. Delay imposing the offset for this number of weeks, beginning with the date the disability insurance benefit would have been offset, the offset first considered date or the day after periodic payment end, whichever is later. Or you impose offset when the resulting number of weeks expire. Not or, this is the steps in A. In B, you subtract the expenses from the lump sum, then you divide the result by the total lump sum, and you multiply this percentage by the weekly rate, resulting in a reduced weekly rate. You then use the new weekly rate determined above to determine the offset of the lump sum. In method C, you subtract the expenses from the lump sum and you prorate only the balance determined above. So what are some considerations that might cause one or more of these to apply? If an injured worker is currently disabled and they're going to be disabled for more than a year, but they're probably not going to be disabled in the future, maybe because they have the type of injury where they're going to eventually return to the workforce, they have plans to return to the workforce, some of these, the timing of the offset may be relevant. That's my presentation.
Thanks a lot. All right, I guess it's my turn. Hey, was anyone spending the night in this hotel last night? Can I get a show of hands? Anybody? What was happening at 1:30 in the morning? Do you have any idea? There was yelling and screaming and cops and fire and brimstone. Yeah. It wasn't me either.
It was Rich discussing apportionment.
Well, I don't know. It was weird, though. Anyway, who am I? My name is Mike Sullivan. I don't know a lot of you because I practice primarily in Southern California. I'm the principal and general managing partner of a medium-sized defense firm, and we just opened our Oakland office here like 6 months ago. So, you know, I'll be up here a little bit more. But I'm best known for writing that book, Sullivan on Comp. Have you seen it? It's like a 13-volume set of black books. I'm not trying to compensate for anything, by the way. All the judges have it. I don't know if you guys know it. Anyway, that's me. And if you look in your materials, I don't know how to identify the section, but my part is Medicare set-asides. And I have the entire narrative from my book on set-asides in here. So, I don't know. Maybe that'll be helpful to you. But I just wanted to identify it. Anyway, I'm not that interesting, so I'll move on. Medicare, as I was reviewing for today, it occurred to me that, you know, not a lot has changed in Medicare the last couple of years. You know, I don't think I need to review for you all the different aspects of the realities of getting a Medicare set aside, because it's something we all live with day in and day out, right? I mean, I can do that a little, but what I've tried to do is identify those issues in practice, practical issues, concerns, things that are kind of out there in Medicare set-aside land. And if you guys have questions or comments as we go along, I'd appreciate it. I've asked my panelists to chime in too. Just because we're kind of in a very practical area here, aren't we? It's like, when do we have difficulty effectuating this? And how do we resolve those difficulties? And so I think maybe that's the best way to spend our time on this today. They only gave me half an hour or so. Anyway, just to go over some of the most rudimentary realities, just to make sure we're all on the same page. You know, Medicare for a long time, back in the day when I was a kid, that was a long time ago, we didn't care. A may need surgery was like $3,000, right? That's how much you paid for a may need surgery anyway, as a defense attorney. Not that way anymore, is it? And what changed it was, of course, Medicare now insists on having its interests accounted for, and Medicare is a secondary payer. So you have to account for the Medicare's interests in every single settlement that you do. It's a common, or was a common misconception, I think, for a long time that Medicare set-asides have to be done. You know, there's the conditions under which Medicare set-asides are allowed to be done, right? It's if you're enrolled in Medicare, if it's over $25,000, right, then you can do a Medicare set-aside. Do you have to do one? You don't have to do one, right? Or if it's over $250,000 and there's a reasonable expectation that the applicant's going in Medicare, and there's lots of different ways there can be a reasonable expectation, but basically it means they're 62 and a half. then you can do a Medicare set-aside, but you have to. And if you do one, does it protect you? I mean, if Medicare signs off on it, are you protected?
You know, if you read Medicare's memorandum, they make a point that $25,000, $250,000, these are guidelines to determine how much manpower they have. These are the ones they're willing to review. But even if we get a Medicare set-aside reviewed, these memoranda point out that that's not a safe harbor. We still have to consider Medicare's interests. It's the consideration of Medicare's interests that is what's required.
Yeah, he's right, and there's no guaranteed. It's so weird because there's this federal agency, and the law is what the memos they put out. You know what I mean? I mean, that's the law that we deal with, is the memos somebody puts out. So that's not so good.
Can I jump in here a minute too? Also, I think when the law was written, the law says to take Medicare's interests into account. First of all, that's what the law says. The law does not mention Medicare set-asides whatsoever. That's basically to preserve Medicare. The memorandums, which were put out by, I think what some people call a rogue agency, CMS, call for this whole procedural aspect of coming up and created this cottage industry of MSA vendors to create these reports that then you would send to Medicare, which is completely voluntary. And you know, a little bit of history with the Medicare set-asides. I was around when it began in like 1999, and a lady came out from Colorado trying to scare everyone, saying you needed to do this or all applicant attorneys were going to be guilty of malpractice. And the defense industry said, this is just a ruse to try and spend more, get us to spend more money. And after about 3 years, then the defense industry had a chance to be scared by the MSA vendors and realize if we don't do this, then we, the carriers, or the defense attorneys even, will all be thrown in jail. And so they co-opted the whole process and said now we had to do it. Now we're going about, what are we doing, about 12 years into it, 13 years into it. Now I think both sides are realizing, wait, it's voluntary. This whole process, one, no one's really reviewing it, and two, it's killing a lot of settlements. So as long as we take Medicare's interest into account, and what does that mean? Well, if you go and have someone put a report together and you pay money, and you sort of rely on that, that's taking Medicare's interest into account. And so I'm seeing now more than ever both people saying, we don't want to submit it, let them come after us, which they won't do, but let's move forward to get a settlement instead of playing by these rules from these made-up memorandums.
Yeah, I know you're stealing my thunder. So, thanks a pant load on that one. Sure, go ahead.
So even though there's the famous Patel memo that talks about these review thresholds, even though a Medicare set-aside is not required, as an applicant's attorney, what I often find for someone who's fairly seriously injured is that until we get an MSA, because the MSA essentially includes a life care plan, for the first time I'm able to itemize for my client what is it that the money that the defendant is offering is designed to pay for. And from a practical standpoint, what I also have noticed is that when I do get Medicare set-asides approved, because I am dealing with a bureaucracy, because my injured worker is dealing with a bureaucracy, and because they can, in many instances, if I'm not dealing with a closed head injury or something like that, they can administer this money themselves. They have the ability to deal with this bureaucracy, advise the bureaucracy when the money is run out, either in the middle of a calendar year in the case of an annuitized settlement or at the end of the expenditure of a lump sum settlement. The injured worker often is more willing to settle, I find, for a more serious case than they are when I don't have an MSA involved.
Yeah, about 2 years ago, we'll get some feedback here. Doesn't sound good. Okay, I think that's better. Move it further away? Okay, like from the other mic?
Maybe.
All right. So about 2 years ago, I had a call from one of my biggest clients, and they're like, hey, we've been doing some analysis, and what's the risk that if we don't do an MSA that they're going to come and bite us in some point in the future? I mean, has CMS given any indication that they're actually going to try and scrutinize these settlements, that we do day in and day out? No. Are they capable of doing it? Yeah. Will we all be retired by the time they do it? I mean, maybe we can get away with it. You know? So I don't know, but anyway, it's blowing all the settlements. You know, it's blowing all the settlements. And it's just something that's intolerable from a business perspective. And so the question became this: what is the value of not submitting prepared Medicare set-asides compared to the risk of them coming back someday and hurting us? And of course, there's simply no way to answer that question. There's simply no way to answer that question. And so, but what I have seen, and this has happened fairly recently, is some of my larger clients are doing that. They're just making the decision. They're saying, look, we're going to allocate, we're going to do a Medicare set-aside, we're going to protect Medicare's interests, we're going to be cool with regards to Medicare, but we're not going to get them to sign off on it simply because the risk is not severe enough, in our view, relative to the benefit of being able to settle these cases. Can I get a show of hands? Who's seen a case where they decided not to submit? It's happening more and more, isn't it? It's like something like a third of the room has seen that already. I think it is going to happen more and more. Honestly, I tell my clients, don't do that, and the reason I do that is to cover my butt. But if I was my client, I would totally do that.
Well, you know what?
You know, the pot odds. If you've played any poker, you understand the concept of pot odds. I mean, come on. Are they really going to do this? And if they do it in what percentage of cases? And if they do that, and how much is it going to cost? And relative to the very, very real reality of what's happening, it's devastating our ability to settle these high-end cases. So we're going to probably see that more and more. Yes?
Do you think that something coming back from CMS in writing stating that they agree on the amount that's recommended protects the injured worker a little bit more now?
Yeah, I mean, from the applicant's attorney's perspective, it's a whole different ball of wax, isn't it? What do you think about that?
You know, when this is really going to happen is when Medicare pays for something. If the money never runs out in the MSA and Medicare doesn't either intentionally or accidentally pay something, then the injured worker isn't going to call me. But some number of years down the road, when the money runs out and they then turn to Medicare, assuming a situation where I haven't requested the MSA be approved, Medicare might say, well, you didn't get an MSA. We determine administratively, bureaucratically, you didn't consider our interest, maybe because the cost of the medical care actually, with 20/20 hindsight, turned out to be much more expensive than was predicted in the MSA calculation that was done, or informal allocation that's done by the parties. That's when it's going to become an issue. So I think from the standpoint of an applicant's attorney, I generally prefer to have MSAs approved. Where I might not do one is if I think that the injured worker is never going to qualify for Social Security. Because remember, the MSA review thresholds apply not only where someone is actually qualified for Medicare, but in a situation where they may qualify for Medicare in 30 months. Assuming my injured worker isn't 62 and a half, and therefore is going to automatically qualify under current federal law at age 65, I'm dealing with a younger injured worker, let's say, who has applied and been denied. Maybe they've even lost at trial, and now their case is up at the appeal on appellate review of the Social Security judge's determination. I had one just recently where it's the exception, but I had one recently where my client went ahead and settled. I was fairly confident that the amount did reasonably consider Medicare's interest, but I didn't think my client was ever going to qualify for Social Security. He lost at the trial, bad, and a non-attorney representative was handling his appeal up in the appellate council. Now, I think the issue, though, is advising my client of the risk. If I advise my client of the risk in writing, and the risk that that Medicare may later say that we didn't adequately consider their interests, and therefore they're not going to cover the industrially injured body part, I've done my job for my client. However, I don't want to get that phone call 10 years from now when I've long ago forgotten about this settlement, that they have not been able to get their medical care covered, and maybe even more so for someone who is, by that point in time, they don't have a worker, an injured worker's attorney involved in the case, maybe because the attorney has retired or for whatever reason, is that injured worker really going to have the wherewithal to take on Medicare? Because once Medicare says, we decided you don't get it, are they going to go hire an attorney to challenge that determination? I don't know.
Well, it's worse than that because, I mean, you could advise your client. Where did I make some notes on this? You could advise your client all you want, but the client, like the applicant, is relatively unsophisticated, right? So, and before Medicare it is, before Medicare will pick up, at least in theory, if they're paying attention, it's not just that the trust is exhausted, but the applicant has to prove that they took that money in the Medicare set aside and spent it all on medical care that would otherwise be paid for by Medicare, which is pretty freaking complicated, right? The donut hole and what they don't pay for and do pay for. Can applicants reasonably be expected, even by their own attorney, to self-administer that? And not only that, they can only pay it at the Medicare approved rate. And when an applicant walks into a doctor's office, the doctor's office is not stumbling over themselves especially when they're getting a fee for service, to make sure they're only charging the Medicare approved rate. So, I mean, realistically, is there a world, realistically, in which an applicant assiduously manages this trust account on their own behalf and only pays what Medicare would approve and at the rate Medicare would have paid for, and then keeps a log of it sufficient that he can prove to Medicare, right? That ain't gonna happen. So I think, I mean, if I'm an applicant's attorney, I'm asking myself, is there a world in which you can truly advise a client to handle that and walk away? Or are you always vulnerable to a malpractice action? Or is your client vulnerable to not being able to use Medicare unless you have like a third party expert helping the applicant administrate? You got no answer for that?
No, I said it's a good point.
It's a real problem. I think.
What I tell injured workers is that if they fail to account for the money and they fail to spend the money in the manner that Medicare is expecting, the risk is that their entire settlement, even the portion of the settlement that was paid to them for permanent disability, that Medicare could require them to spend that entire settlement on their medical care before covering it. But we still then run into the problem of proof. Did they throw the receipts away as they got them, or did they keep them and keep a log, and as well as list what the diagnosis was and the CPT code and other things that Medicare might require?
Go ahead. As a practical matter, doesn't the applicant just get his medical treatment anyway? Well, maybe, but I mean, the point is that Medicare, in theory at least, won't pick up unless there's proof of exhaustion of the trust. Well, I mean, the whole point is that Medicare never, we all live in a world where these realities are subsumed in the fact that Medicare never does anything. But what happens if Medicare starts doing something? We're all screwed.
And there's another option, and I'll steal my own thunder on this one. We now have the Affordable Care Act, and you can't buy an Affordable Care Act policy if you're on Medicare or on Medi-Cal. So what happens if early on in the decision-making process with the applicant attorney, the decision is made not to immediately apply for Medicare? Maybe the purchase of an Affordable Care Act policy, which will allow them to treat maybe during UR and IMR denials, settle the case within a relatively short period of time, which is the goal of this process anyway. And then after, if you don't have Medicare, you don't have an MSA, it's not going to hinder the process. And at a later date, the applicant can then apply for Medicare and has gone through the process without having a large MSA kill the settlement. Just a thought.
Yeah, it's problematic on multiple levels. I guess my point that I was getting around to is you know, if you're faced with the possibility of a Medicare set-aside being done but not sent in for approval, and you're worried about protecting your applicant interests or yourself, what have you really lost given the overall realities of what we're doing on a day-to-day basis with these set-asides? I think the subtext of my clients when they decided to take this risk was really, we're not protected anyway, are we? Not really. So I think that's kind of the subtext of the idea where you just don't submit. There's additional problems and issues too. What happens when the applicant spends, you know, people always say, they say to me, what if you win $1 million? And I say, well, I'm gonna take $500,000 and go to Vegas and spend it on drinking and raucous living, and the other half I'm just gonna waste. So, you know, applicants tend to do that. Sometimes they misappropriate the funds, and there's a couple of cases. There's one in Mississippi where he used the money to buy a fishing boat, right? And then there's another one in California where it was not deposited in an interest-bearing bank account, but instead was converted to cash at a check cashing store. Okay, so what happens there? Well, in both cases, Medicare denied liability for the medical treatment. They said, you did not exhaust the trust. So, hey, I guess it did happen. So then they tendered invoices to the employees and said, please, you know, pay us back for your Medicare use so far. And in one case, the employee initiated litigation against the employer, arguing that the employer failed to fully explain the MSA trust fund requirements. So how are you going to keep your applicants from spending the money and suing you? Are you going to give them, you know, written advisement? Are you going to, you're going to do that, right? You're going to put a piece of paper in the CNR, which is really long and complicated, and says, don't do that. Is that going to work in a civil suit against a relatively unsophisticated applicant? Can an applicant's attorney ever credibly advise the applicant to do this? I mean, I don't know. I think there's vulnerabilities built into the system. Anyway, that's an issue I came up with. Another one was, what do you do about attorney's fees when it comes to settlements? I mean, this happens sometimes. You go to court and you say, okay, the Medicare set aside is $200,000. And there's like maybe $10,000 worth of non-covered care, and the PD's worth $100,000. Does the applicant's attorney get a fee on $310,000, or does the applicant's attorney get a fee on $110,000? Can you get the fee?
310.
300. I mean, the applicant's attorney is going to want to get the fee on the whole thing. That's the whole point of a CNR, right? Otherwise, just stip the thing. I mean, from an applicant's attorney's financial perspective, which is, of course, not the whole deal. I've seen applicants' attorneys not take the whole thing. Did you ever do that?
Yeah.
You not take the whole thing?
Yeah.
Is that because you don't feel like you're entitled to it, or because there's no logistical way to do it?
It's a question of closing a file.
What do you mean? I mean, let me ask you this.
There are times that I'm just not going to be able to settle that case if I don't cut my fee. If I don't like my client a lot, and I want them out of my life, I might take less of a fee.
Yeah, Richard said at the beginning we're being streamed on the internet here. Yeah. But it's a problem. I mean, there's no money. Where does the money come from? Out of the PD? I mean, the PD advances are 50 grand, and you're already taking 15 grand, so the applicant's getting like 40 grand on a $310,000 settlement. It depends on how badly your client wants to settle the case. Yeah, that's true. I guess it's just a practical question. I haven't seen too many judges deny the fee. Has anybody seen a judge say you don't get a percentage on the fee? There's one guy. Let's see a show of hands for people who have seen that. Well, that's a lot. On what theory? There's no cash. So is it just a practical theory, like the applicant's it's just not equitable to the applicant? Oh, there's a case on it? Whew, I really should know that. Is it like? Tell me it's a recon or something. It's not published. Okay, all right. I'm off the hook. All right.
That case said that you can't pay the attorney's fees and reduce the MSA. That's all that case said. That case.
Okay, so this man says that that case actually just stood for the proposition that you can't take the attorney's fees and reduce the MSA, which of course you can't because Medicare is not going to let you take a fee, right? It just destroys the whole MSA. I've seen applicants' attorneys get real creative with all the different stuff that Medicare doesn't cover and then take their fee from that. So they say, well, you don't get your mileage, and there's a donut hole, right? Which you know is like, the donut hole is where for prescription meds, Medicare covers you to a certain amount, and then they stop and they pick up and cover you again, and they give you a little bit in between. They give you like 55% or something. And they say, well, that's not covered, and that's not covered, and that's not covered. And look at all the stuff 4600 covers that doesn't get, that's not covered. And there's medications that aren't covered in Medicare per se. So they do that. Applicants do that a lot, and then they say, and then that's my fee, right? But it's still a practical issue because there still may not be enough left in the kitty to take some more fee.
Well, I think it's just important to note, and I'll say that the MSA does not equal future medical care. The MSA is only that part of future medical that Medicare pays for. So I don't know if you're sort of being sarcastic about it or not, but there is donut holes, there are co-pays, they exist, they're not wiped out, they're on the federal governmental websites if you want to check it out, and so that's where the fees and that's where the cash upfront comes from. But it's not a trick to try and get money. It's that the future medical is much greater than an MSA.
A real significant one is where a drug is being prescribed off-label. So when a drug is originally approved by the Federal Drug Administration, for instance, it might be an epilepsy drug. But later on, doctors find out that that epilepsy drug has the ability to be prescribed in other settings, maybe for muscle spasm. If I'm not mistaken, for instance, I think Lyrica is one that is often prescribed and ends up being prescribed off-label. And so if a person is taking that medication and is expected to continue taking that medication, that could represent tens of thousands of additional dollars over their lifetime for that single medication. And it's not always enough, in my opinion, when I'm looking at an MSA calculation, especially the MSA company is often chosen by the defendant, not by me. So I'm somewhat skeptical of the document when I see it. Some of the better vendors, better in my opinion, include a section that talks about non-Medicare covered expenses and itemizes that out. But if that section is absent and I know my client is on a particular medication, I can look it up on the website. I can have my client call 1-800-MEDICARE, but I can find out whether that's a covered expense, and then I'll bring that up.
Yeah, medications in particular are a whole other topic. They insist. When I talked to like a lot of my managing attorneys before I came in today just to see what kind of issues they faced, and one of them was saying, "Man, it's so hard when they insist on brand name drugs, even though the patent's about to expire like a year and a half. Medicare just doesn't care. Like they insist on a Medicare set aside that says that it's going to be, a name brand forever." It's ridiculous, It's like any doctor's report says this may be necessary. They insist that it's going to happen and it's got to be in the Medicare set aside. So it's a killer. Like Celebrex is like that. It's about to be expired, but it doesn't matter. You have to put in Celebrex for life at the brand name cost. So it's pretty brutal. Another issue that comes up sometimes is, submission and approvals is a big deal. It used to take so long to get them back. But lately they're coming back pretty fast, huh? Like a year ago, they seem to have fixed it, is what I hear. You were telling us, someone over here was telling a story about a 4-day turnaround or something like that. Yeah, I've never seen anything like that. But, my people are telling me it's like 2 to 3 months now. Is that about what you're seeing? No? What are you seeing? Huh? A year?
Let's discuss it. If you're seeing a year, then someone's missing some communication where they're asking for more information, because most recently, there's a move, this was discussed with the applicant's attorneys, that an applicant attorney can register with CMS and file their own MSAs. And I had a client last week 2 weeks ago who filed for herself, obtained the number, sent up the MSA, got the 2 years of medical reports and the prescription information and sent it up, and it came back in 4 days. And it came back as a lump sum, even though it was requested as a annuity breakdown, and so it took them just 1 more day to come back with the breakdown. Another one, I think a couple weeks before that, took 1 week. So I think that's interesting, because are there fewer settlements? But they're definitely coming back, if done properly and through a portal, they're coming back in 2 weeks or less. So I also encourage you, because I also have some up there that have been up there 8, 9 months, and that's interesting. I think that needs to be researched, how all of a sudden are there ones coming back so quickly, but there's ones up there 8, 9 months, and I think we need to push a little and push the vendors to find out or call ourselves, how is that happening? But right now, they seem to be happening almost in a matter of days.
Yeah, it's a lot better. One of my people said that they had some success writing a joint letter to CMS and saying there's financial hardship on the part of the applicant. Did that in a couple of instances, and then it was approved much more quickly. So that's pretty good. I guess you could try that. Another thing that comes up sometimes, and this is crazy, because you submit it to CMS, and then they'll either approve it, or they'll say, no, it's actually more, and they'll give you another number, right? You submit it for 100,000, and then they'll say, no, it's 120,000, because we identified all these other things in the medical. And then you can either agree to the 120,000 or not, but they won't negotiate with you. So it's just not reasonable. And that happens a lot. And that's a bummer, because you have this great settlement, you've killed yourself to work out, and the Medicare just kind of comes and kills you. But what's happening more, that we've seen a few times, is that they'll come back with actually less than you asked for. You ever seen this? Who's seen this? Where Medicare comes back and says less than you asked for. So you send in a $100,000 MSA, and they say, no, it's only 70 grand. And then the applicant says, I get 30 grand, I get 30 grand. Defense says, no, you don't, no, you don't. That wasn't what we negotiated. This is just X plus the Medicare set aside. So we see that happen a lot. I don't really know what to do about that. I guess it just depends on who's more greedy.
Negotiated going in. I don't do this a lot, but last week I was at an informal settlement conference, and a specialist came from the insurance company and said, look, we've worked out this agreement. It's subject to CMS approval, but we want the case closed. So if it comes in lower, your client gets more money. We negotiated it.
One thing I've found that can be of use is if you have a large self-insured client, sometimes they have health care that will pay the applicant even in the event of a CNR. This happens a lot. They have the really generous health care plans. So if you're a defense attorney and you have a large self-insured entity as a client, then sometimes their health care, you see it out of the case, but the health care will still pay for the applicant. Which is weird, because it's their money either way. It's usually they're so large that they're self-funded, both on the workers' comp side and the other side, but they don't care, because their work comp side is trying to close down their reserves. So they don't even care about the fact that they're going to pay for the medical care twice, which is kind of weird, but it happens. Or they care about it, but they just have different departments, you know what I mean? So in the event you have a self-insured client that has non-industrial health care that would otherwise cover the industrial condition post-CNR, well, then Medicare's interests are taken care of, aren't they? Because Medicare doesn't have liability, because the health care is going to pay for it. So I think this can be an unexplored area for the defense. You might want to look into it if you represent large self-insured entities. Now, let me repeat it so you make sure everyone's on the same page. I'm getting a lot of funny looks. The idea is that the applicant has health insurance that's going to cover the industrial condition even post-CNR. Therefore, Medicare is not going to be used. And so you don't have to do a Medicare set-aside or even account for Medicare's interests, because you've already accounted for them, because you're providing the medical care through the non-industrial health portion. Okay? Now, that won't necessarily work, because the applicant can still elect to go to Medicare if he or she wants to. Right? I mean, the applicant's still entitled to go to Medicare. So that can blow up in your face if you're the defense. But, it's not a very realistic risk, because, who's going to go to Medicare when you can go to, a large self-insured HMO? Yeah, Medicare is cheap, more cheap than than what's out there in the world of self-insured insurance, right? Okay, and then I think I'm running out of my portion of the time, but there was one more thing I wanted to mention. Medi-Cal set-asides. Medi-Cal set-asides. It was effective September 30th, 2010. There's a new labor code. It was emergency legislation, and it gives the Department of Industrial Relations permission to transmit information to the Department of Healthcare Services with the purpose is to enable Medi-Cal, right? That's state of California's charitable medical stuff as opposed to the federal charitable medical stuff, right? That allows Medi-Cal to recover monies expended for medical care on behalf of the state of California that should have been paid by workers' compensation. So there is statutory authority in existence at this time that allows them to file a lien against your case and get their money back. Has anyone seen a Medi-Cal lien? There's one. Deborah saw one. There's another one. Not many, huh? Why? Why is Medi-Cal not getting its money back from workers' comp? Because they have to file a lien? Well, why you can file a lien? No, it's because they're not paying attention. It's just like everything else in the state of California government, right? The main reason they're not doing it is just because they don't have it together. But they could get the money back if they tried. And shouldn't there be a set aside for Medi-Cal as well as Medicare? So I just wanted to make you feel a little extra bad today. There's really no reason why their interest shouldn't be taken into account. And you're always vulnerable if they're involved in the case.
Another corollary to that is that as an applicant's attorney, I'm looking at someone's Medi-Cal entitlement and realizing that when they receive money, they're going to lose their Medi-Cal entitlement. So I sometimes will arrange for a special needs trust, which is a type of trust where the trustee is prohibited from spending the money in the trust corpus in a manner that would disqualify them from receiving public benefits. The other interesting issue that came up recently was a client said to me, well, so I get $150,000 or $200,000 in a Medicare set-aside. There's no Medi-Cal involved. What if I run into someone with my car and get sued? Can my creditors get that money? And I spoke with a bankruptcy attorney I know, and he said, yeah, they could get that money. And then Medicare is going to still want to be able to be shown receipts totaling the amount of money that was in the Medicare set-aside. And so what we actually considered, and we didn't end up doing it because my client couldn't find anyone he trusted, or couldn't find two people he trusted. But we were very seriously considering doing a spendthrift trust, which is a type of trust that is an irrevocable trust, and therefore it is very important that the injured worker have someone they can trust. But the purpose of a spendthrift trust is to shield someone's assets from their creditors.
I'll turn it over the mic.
Hi, I'm happy to be here, and I want to thank Richard for having me. He and I did a panel at the State Bar I spoke on the Affordable Care Act, which doesn't have a lot to do with work comp, but I figured out a few things to say, and he wanted me to come here, so I appreciate it. What I've done for 29 years is I'm a structured settlement consultant, if you need to put a label to me. But what that means, or what I discovered early on, is that I have to be a problem solver. Because if you don't solve the problem, the case isn't going to settle, and ultimately then I don't make any money, though I truly enjoy what I do. And so, you know, one of the biggest problems I tend to deal with sort of complex and catastrophic cases. I've been around a while, I'm sort of good at what I do, so I tend to see some of the larger, badder cases. Is what are we going to do about future medical care? So I work a lot with applicant attorneys up and down the state. I do have defense clients, but I put together plans that help injured workers settle their case and take control of their lives, namely medical control. And I've tried to take a mountain of information about the Affordable Care Act and sort of want to give you a little bit of nuts and bolts and see how maybe we can use the Affordable Care Act in the settlement of cases, because as a problem solver, the future medical seems to be the problem. We have UR, we have IMR denials, and applicants and applicants' attorneys, wouldn't you say, just feel they can't get the medical care they feel they need and deserve. And so maybe the Affordable Care Act can address that. So I put together some materials in the book, but I also then felt I wanted to add a little more, so I'm going to read a little bit of what I created, and then we'll go through material in the book and ask any questions. So I think it's an interesting subject. Has anyone just come across having to use an Affordable Care Act policy in the resolution of a comp case yet? Oh boy, tough crowd. Well, let's see. I've done it a few times, and I'm going to sort of maybe try and open up some eyes and doors and see it can be helpful. So I think we should maybe just talk about it. So, you know, there's a lot of emotion around the Affordable Care Act and the policies that are available through the exchanges. But I think that the Affordable Care Act policies, which we'll go over, might be able to provide us, the work comp community, with some new opportunities for settlement of comp claims. For a long time, they were putting it together. In the beginning of last year, it finally came into implementation. You remember there was the whole mess with the website. No one could sign up, and then no one knew how many people signed up, and all that kind of shenanigans going on. And I think the new law has been under constant attack since it's been put together, and so everything is constantly changing. And what we'll talk about here today is, I think, the best of what's happening at this very moment. In fact, there's oral arguments, which we'll talk about in a moment, at the Supreme Court. And who knows what this law will be, but it exists. I don't think it's going away. I think there'll be changes, but I think we need to possibly look at it, because it is going to, I think, hopefully be a tool for us. I want to talk about, and what I have in my handout materials, we're going to review sort of what the basic coverage is. The Affordable Care Act are actually health care policies, and there's essential benefits that the government said needs to be in every single plan. And I think we're going to have to learn what are those coverages and how can we use them in the resolution of a comp case. It's going to be important to understand what this new law, these new legal policies, as they're known, cover and what they don't cover. And we're going to have to make sure, as we do with Medicare set-aside, as I said, what's covered in an ACA plan, what's not covered in an ACA plan. We're going to have to make sure that we put into a settlement those components of a ACA policy that aren't covered. And it's sort of similar, once again, to Medicare, that they don't cover home care, they don't cover transportation. I'm also going to discuss maybe how, if you know early on, if someone is on Medicare or Medi-Cal, that's going to be very important to know, because you can't get an Affordable Care Act policy if you're on Medicare and Medi-Cal. One of the reasons is that Medi-Cal and Medicare are part of the Affordable Care, for the ACA framework. Those are legal policies. And so if you're on Medicare, Medi-Cal, you cannot opt out and decide, well, I want a more regular Affordable Care Act policy. You have to stick with it. But what I think we're going to find, and what I think is very positive about the Affordable Care Act, and I don't know if this has been pointed out, is I think it's going to give opportunities for certain individuals who, under the old system, they weren't able to receive any type of care coverage once their comp case settled. And I think now they're going to be able to find a way to find some health care coverage. And the reason was the elimination of the pre-existing exclusions and the dollar caps. In other words, now anyone, no matter what your medical condition, and sort of no matter where you got it, is going to be able to get coverage for that condition, that pre-existing condition, and there's not going to be a dollar cap coming in.
I have a question on that.
Sure thing.
Where the Affordable Care Act policy is a group health coverage. I know in California, and maybe across the country, some time has been given to employers before they have to buy group policies that are Affordable Care Act. But if an employer has bought an Affordable Care Act policy for their employees, would that provision you're talking about apply there too?
It applies both to group plans and to individual plans.
But not to group plans that were grandfathered or grandmothered in and entering into the Affordable Care Act arena has been delayed?
Right, so there's all sorts of levels. I don't want to make your heads explode, because my head exploded enough for all of us putting this together, but there's new policies, and then there's sort of, for group plans, there's grandfathered policies, and a grandfathered policy doesn't have to have the same requirements as a new policy. So I don't want you to get lost in that, but yeah, you're going to have to be, I think as life goes on, as the world goes on, we're going to have to become smarter and smarter about what we're being offered and what our responsibilities are. And so, very good point. It's unbelievable how complex this law actually is, and so I've tried to sort of refine it. But as I was sort of saying before, I think an Affordable Care Act policy is going to give a safety net to people who could never before have health care coverage, just as sort of Medi-Cal and Medicare provided a safety net. Once the MSA was done, what would you do? Well, you'd have Medicare, or Medi-Cal didn't, once you got on it, it covered everything. Well, an Affordable Care Act policy is going to operate sort of the same way. And everyone runs around very worried, especially around election time. Everyone worries, well, Medicare might not be around forever. And Medi-Cal is definitely going to be expanded. In fact, one of the ways that the president got a lot of people to be covered under the Affordable Care Act was to expand Medi-Cal, and we'll talk about that. And we also have the future of the Affordable Care Act is being called into question, daily, and we'll talk about that in a moment. There's going on lawsuits every day and more being filed. So it's going to be interesting for people like Ben and an injured worker to decide, well, what do I want to do? Do I want to forego work comp coverage and go with an ACA policy if I can never understand it, or do I stay within the work comp system? And that's difficult because there are denials of care, but do you jump into a system where you really don't know what's going to happen or what it's going to morph into? So it's going to be a tough decision. I think it's going to take a while for us to figure that out, but at least there's going to be an opportunity for people to get out of the work comp system and have some type of coverage if it works for them. There's going to have to be a lot of questions answered because the policies are only offered at certain times. There could be gaps. What do you do if you settle a case outside of the window? We'll look at some of those things. I think structured settlements, just in my own self-interest, I think they'll be around. The annuity payments can pay for the premiums. The annuity payments can pay for those pieces of the medical coverage not covered by an ACA policy. So we'll see, that's a good way to provide those payments. The UR and IMR process is definitely making getting out of the system much more attractive to people. And so let's sort of maybe, explore what can happen with that. In my handouts, I sort of put over a little of the first couple pages are an overview, and I want to sort of quote what the president said. In March 23rd of 2010, the president signed into law the Affordable Care Act, and he termed the most important piece of social legislation since the Social Security Act passed in the 30s, and the most important reform of our health care system since Medicare passed in the 60s. And the health care, the ACA actually is sort of two different pieces of legislation. It's the Patient Protection and Affordable Care Act and the Health Care and Education Reconciliation Act. And these two laws are known as the Affordable Care Act or Obamacare. And here's what it does. Here's what I think the goal of what the President and the Affordable Care Act is trying to achieve. It's in essence creates a national framework for near universal coverage and outlines strategies to increase access to affordable, improved health care and contain costs. So like the main goals, I think as I put somewhere, the main goals is to decrease the number of uninsured Americans and reduce the cost of health care. Now, determining how the Affordable Care Act impacts with workers' compensation is challenging because if you read through all this law, that whole stack, it doesn't mention workers' compensation anywhere. And what it specifically doesn't do is it doesn't try to integrate workers' compensation with the rest of the healthcare system. If you remember back in the Clinton administration, Hillary in '93 tried to she was very good at trying to integrate the workers' compensation system with the general healthcare system, and that was a crash and burn. No one was really interested in doing that at that time. To go through, so this is a state and it's a federal program, and there's lots of agencies involved. We have our friends, CMS are involved. We have the Department of Labor because businesses and employers are supposed to be part of this Affordable Care Act. We have the Department of Treasury because they're going to make sure you pay your fines and fees and penalties if you don't join and get a healthcare act. So everybody's in this party all together. I know Mr. Montalvo likes cites, and lawyers like all sort of cites and regulations, so I put on some of these pages, you know, you can read yourself silly to all the different parts and pieces of this legislation. But there's some important parts of the state legislation, I think, that can really help us. And it's like, you know, dependents can be covered up to age 26. And there's preventative services with no co-pays. And we created an exchange. And there's a benchmark plan, sort of what should the plans look like. And there's definitely an expansion of Medi-Cal. As I said before, medical costs associated with work comp are only 2% of the expenditures of the whole medical expenditure of the United States of America. So while we're busy every day and overwhelmed, we're actually involved in such a small part of the medical expenditures for this country, which is actually very weird. And like I said, because we're so small, the president and the legislators had no time for us. So I sort of wanted to go over what you don't have in the handout. I want to go over a little bit how it works, because you hear, well, there's the Affordable Care Act and maybe someone can get on it. So I want to give just a few minutes as to how it works. So we in California created our own marketplace. The states were given the choice. Do you want to create a marketplace? Well, first of all, the law wanted all the states to create it, and you know, everyone wanted to fight on this legislation. So some said yes, and 26 states said we don't want to have a marketplace because they didn't even want the law. So then the federal government had to come in and create an exchange. And an exchange or a marketplace, they're interchangeable. That's where you buy the Affordable Care Act policies. In California, we have what's called Covered California, if you've heard of that, and that's where you can basically go online. And you can window shop, and you can go online and you can give them some information about your age, and you can give them information about where you live, and they will let you look at the different policies. You don't have to buy anything at that point. You can just shop, and then if you decide, oh, I like one of these policies, you can buy it right online. It's actually fairly easy. Now, you can only buy these policies at certain times. They're called open enrollment periods of time. And so this is going to come into play if we start using this more and more. The open enrollment for this year was going back to November 15th of 2014, and it ended at February 15th, 2015. So if you want to try and use an Affordable Care Act policy, the rest of the year, we're going to have a little bit of a problem. But there's some exceptions how you can buy a policy, and these are called special enrollment times. And these are, like if you lose other coverage, if you quit your job, or you're laid off, or you lose your hours, or if you're a student, and you lost your student health coverage, you can enroll at that time. If you gain a dependent, if you get married or give birth or adopt a child, you can buy at that time. If you get divorced or legal separation, if you move to another state or another part of the state where your network isn't applicable, you can buy then. If you're on COBRA and COBRA runs out, then you can buy a policy no matter what time of the year that occurs. If you lose eligibility for Medicaid, if you're enrolled in a marketplace plan and then your income increases or decreases with these, so you don't get the subsidies, you can buy it then, or if someone makes an error. And basically what the person does is you decide what plan you want, you send the money into the insurance company, they send you back a card, and that probably takes a while, so hopefully you want to keep the confirmation, and you can start using your medical card, your ACA card, to start getting treatment and start getting pharmaceuticals if that's what you need. I want to talk about sort of what do the plans look like, because this is always interesting. I mean, if you talk to people, including us, we don't even know what any of these things are. So if you go to the quick overview of ACA basics, there's one page and then on the back. And so the Affordable Health Care Plan is divided into 5 levels. Though only list 4, we'll get into that. It's platinum, gold, silver, bronze, and there's something called catastrophic. And how are these plans different? Well, they're different based on the percentage that the plan pays versus the individual. But before we get into that, let's just talk about that every plan has to have the same components. That's not what separates them. Every plan must have the 10 essential health benefits listed on that page, the quick overview of ACA basics. It looks like that. And on top of that, there's some very important points, and this is maybe the most important part of sort of the ACA, is that the health insurer is required to cover emergency room visits without prior authorization. So you're not sitting in the ambulance and they have to call and see, will they let you in? They have to pay, the Affordable Care Act provider has to pay no matter what. They don't require authorizations for OB/GYN care. The health insurer may not impose any pre-existing exclusions, which is probably the most important part of this whole law, and especially important to us. They can't be discriminatory in terms of fixing rates. The rates can only be allowed to vary based on whether the plan covers an individual or a family, where you live, and your age. The health insurers participating in the exchange must accept every employer and individual in the state that applies for coverage, except maybe grandfathered policies, and they can't dump you. As long as you pay your premium, they cannot decide at the end of the year, you know what, you're just a mess, you're out of here, that was ended, which is probably the second best part of this law. Now let me tell you how these different plans, here's how the plans are different from the gold and silver. Okay, so the health plans are differentiated by what's called an actuarial value, which, I don't know, it took me a long time, I'm not that bright, but what's an actuarial value? And that refers to the average percentage of the health care expenses that the plan covers. So a plan, platinum or gold, is divided into two parts. It's how much the plan pays for and how much you pay for. So on average, a platinum plan has an actuarial value of 90%, gold is 80%, silver is 70%, and bronze is 60%. So a higher actuarial value, like a platinum plan, means a higher premium, but a lower deductible, copay, or coinsurance. That's the big difference in these plans. All cover the same thing. How much do you pay for the premium and how much do you pay out of pocket? So as an example, the bronze plan has an actuarial value of 60%, which means the plan covers 60% of the medical covered expenses, and these are all theoretical. And then the individual is responsible for 40%. And so the 40% can come in the form of a higher deductible or lower coinsurance once a deductible is met, or a lower deductible and a higher coinsurance. But the benefit of the lower bronze plan has a lower premium. So the bronze plan is good for someone who does not expect to go to the doctor a lot or get many prescriptions. On the other hand, the platinum plan is better suited for someone who goes to the doctor quite a bit and has regular prescriptions, probably people we deal with more. And the plan has the highest monthly premiums, but the lowest out-of-pocket expenses. And then the catastrophic plan is basically for people who are under 30 and who are really have a hardship, and so it covers like 3 primary care visits and some preventative services, and has a very low premium. But if you do get that serious illness or you do have that serious accident, you're going to be paying quite a bit. Now, so just to recap, because I want you to understand, so we do nothing else, and say I sort of heard something about the Affordable Care Act, is all the plans cover the same benefits. The monthly premiums are higher with the higher plans, like platinum and gold, but the out-of-pocket expenses are lower. And then vice versa, the monthly premiums are lower with the lower level plans, silver and bronze, but the out-of-expensive costs are higher. When the covered individual, needs care, they're going to be paying more. So it's important to note and sort of understand what the actual individual worker may need, and then you can pick what plan works best. So move along. Now there's also a maximum out-of-pocket, and so this year it went up. So the out-of-pocket, the maximum anyone has to pay is $6,600 out of pocket, and $13,200 for a family. So that's capped as well. So it's not like you get into it and then you can go bankrupt because you have to keep paying these copays and deductibles. It maxes out at $6,600, but that doesn't include the premium. So what ACA policy costs is a max of $6,600 plus the premium you choose. Employers are part of what makes this whole system work. The employers have to provide coverage. If it's less than 50 people, the employer doesn't have to cover full-time or part-time or anyone. They just don't have to, and there's no tax penalties. With businesses of 50 more employees, the employer has to pay for full-time employees but does not have to pay for dependents. So it's really, you can see there was a lot of wrangling between business and the government. I think the president and his people wanted everyone covered, and you really had business pushing back, really limiting it. And so we have businesses are providing some of the affordability in the Affordable Care Act, but maybe not as much as they could. If you buy through the exchanges, because you can always go to an individual insurance broker and buy. That's called the open marketplace. But if you buy through these exchanges, there's subsidies. And that's determined, I don't want, once again, this is too much, but it depends on how much money you make in relation to the federal poverty level. And basically, you can get a subsidy. The government's going to help you pay your premiums if you're an individual making, let's just call it between $12,000 and $46,000. There's going to be some assistance the government's going to give you. And the way they determine that, once again, is you get on the website and they're going to ask you for your income, and it's what's called the modified adjusted gross income. So they're going to say, you know, you're going to ask you what are your wages, salaries, tips, net income, self-employment, money from a self-employed business, unemployment compensation, SSDI, alimony, retirement, et cetera. And they're going to come up with how much is your income, and then they're going to decide you fall within this percentage of the federal poverty level and give you some assistance. Yeah, Ben?
Do those extended Medi-Cal plans include no pre-existing conditions as well? Is it an Affordable Care Act?
Medi-Cal now?
No, where you're qualifying for subsidies.
Okay. Does it include what?
Does it prevent the insurance company from excluding pre-existing conditions?
No. No, you cannot. There's no way to exclude based on pre-existing conditions. So real quick, how does the government help people? This is sort of interesting. The government does one of two things. They either share in the cost, so they reduce the out-of-pocket costs. That's called cost sharing. And then they make you buy a special silver plan, or they will give you a tax credit at the end of the year. And you can, when you file your income tax return to pay based on how much money you made, you can apply for a tax credit. I want to move along here quickly. Now, you know, there's an individual mandate, and this was legislated, and this was then litigated, like almost every other part was. So if you're an individual, you have to carry health insurance. You have to have a plan that has these 10 essential benefits, and if you don't, there can be a penalty that was last year a minimum of $95. This year now it went up to $325, and if you made a lot of money, then it can be almost the cost of a yearly premium for a bronze plan. So last year it wasn't so bad if you didn't have coverage. It's starting to get, it's going to take a bite into you, and that's going to keep on increasing. What's very unfortunate for me or for us is that the Affordable Care Act does not extend to undocumented workers. And there's nothing on the open marketplace as well. So if you're undocumented, there's only really one place to go, and that's emergency Medi-Cal, and that's for another conversation. The last few minutes I want to talk about Medicaid and Medicare. So we can turn to the handout that says Medi-Cal and Medicare under a new health care system. So initially the president wanted all the states to have this expanded Medi-Cal, and they fought back, and so the states could opt in for expanded Medi-Cal or not. And let me explain why this is important. First of all, we jumped in. California, we jumped in. We said we want expanded Medi-Cal, and we're fully in. And that means that now low income, non-elderly, before you had to be elderly, non-disabled, before you had to be disabled, without dependent children are eligible for Medi-Cal. Before they were not. And so, because the goal is to reduce, remember, the number of persons without insurance. Medi-Cal goes back to 1966 when it was established. There's about 8.5 million people enrolled in Medi-Cal, but with this new expanded Medi-Cal, it's going to be another 1 to 2 million people. So we're going to start seeing more and more people that we're dealing with in Medi-Cal. And what's also important is that this new Medi-Cal, which is different than the old Medi-Cal, it doesn't have the in-home supportive services, and it doesn't have some of the other benefits. There's no asset test. Before, if you had more than $2,000, as you remember, you couldn't get on Medi-Cal. They don't look at that anymore under new Medi-Cal. It just says if you make under a certain amount of money, you're going to get Medi-Cal. And that's interesting to us because work comp payments of a settlement aren't counted as income. So you can actually have someone in Medi-Cal settle their case and have them not to lose their Medi-Cal, which is very important to us. Medicare is roughly staying the same. They're trying to tighten it up. They want to try and preserve it. You know, will that mean that MSAs are going to be reviewed more closely? I don't really think so. I want to finish in the last 5 minutes and go back to what I had sort of brought up a little earlier about how can we use ACA in the settlement of our cases, and so I'll sort of review. And I think it has to do with, at the beginning of a case, when Ben goes to take a case in, does he have someone sign up for Medicare or does he not? If you don't sign up for Medicare, you can buy an Affordable Care Act policy. If you sign up for Medicare and you go to the state exchange and they say, have you signed for Medicare? You say yes, they will not let you go any further. So we're going to have to maybe think about, or if you're dealing with someone in pro per, do you immediately run to Medicare, or do you maybe wait, buy an Affordable Care Act policy, and are able to treat, even though there's UR and IMR denials, you have this medical policy that has to pay regardless of where the injuries came from or any pre-existing conditions.
You know, there's a 24-month waiting period for Medicare from the onset date. Do they qualify for the ACA during that waiting period?
They will not. They will not. So if you apply, you're going to have to go outside of the exchange where the subsidies are, and you can maybe buy something in the open marketplace. So the question is, though, and that's going to probably be too expensive, so what do you do? And I'm going to put something out there that I wish everyone wasn't listening to, but I'm going to throw it out there that you can get around the MSA process, because if you haven't applied for Medicare, then no one's going to be running around going, well, where's your MSA? We know that MSAs, especially the prescription portion, are causing a lot of settlements to just fall apart because the carrier goes, I'm not going to pay that crazy. Why would I pay on a case that has heavy prescriptions? Why would I pay that when it's costing me a lot less than this, average wholesale price put on there? It's not going to work on every case. But maybe if we don't go running, we rethink a little bit and we don't immediately run to Medicare and we don't have to deal with MSAs, we might be settling more problems. And Ben can come in after the case is settled and then sign up the applicant for Medicare once the settlement is complete. Other than that, to use these policies, we're going to have to figure out if they're available. We're going to have to figure out what they cover, what they don't cover. You can use life care plans, bad words to some in this room. There's other ways we can figure out what does an applicant need, but I think we can provide for certain people, younger people, seriously injured, who are not going to have Medicare and Medi-Cal, a way to take a serious injury, have it covered, let them get out of the system, control their life, and let us all move on. So we're going to have to wait and see how this all plays out, but I think the Affordable Care Act is going to come into our lives more. It hasn't yet so much as I can see, but I think as we talk about things and we really maybe learn a little bit more about it, we can start to use it in the settlement of some cases, which I've been able to do. Thanks.